Hello, friends, and welcome back to my channel, Advocate Pramod Bhardwaj Speaks. I'm Advocate Pramod Kumar Bhardwaj, an advocate with over a decade of experience in handling complex family law cases. Today, we are discussing one of the most emotional and challenging aspects of family disputes, child custody, and exploring how Indian courts decide such cases based on the best interest of the child. This episode is for fathers, mothers, and families who want to understand child custody laws in India, the legal provisions, and the step by step legal process and strategies to help you navigate a custody battle successfully. How do the Indian courts decide who get custody? Many parents believe that the court automatically grants custody to the mother or the father based on gender. This is not true. The guiding principle in child custody cases is always welfare of the child. Courts do not just consider financial status, educational qualifications, or property ownership, but rather which parent can provide the best possible life for the child. Under Indian law, the following statutes govern child custody matters: Guardian and Wards Act 1890. A parent seeking custody must prove they are the best guardian for the child. Hindu Minority and Guardianship Act 1956 governs child custody for Hindus, ensuring that the welfare of the child is the topmost priority. Special Marriage Act 1954 covers custody rights for interfaith marriages. Muslim, Christian, and Parsi laws. Each community has separate laws, but courts ultimately focus on child's well being. Now, where and how to file child custody petition. If you are seeking custody of your child, you must file a custody petition in the appropriate court. Where to file? The Family Court has jurisdiction over child custody cases under the Family Courts Act 1984. The petition must be filed where the child ordinarily resides. If the child has been wrongfully removed from the jurisdiction, a habeas corpus petition under Article 226 of the Constitution of India can be filed in the High Court. What to include in the petition? Details of the child, name, age, school, health conditions, existing living arrangements, who is currently caring for the child, why custody should be granted to you, your financial, emotional, and physical ability to raise the child, stability, family support, and emotional bond with the child, then evidences supporting your claim, school records, medical history, photographs, financial records, and any previous court orders, prayers before the court, seeking full custody, joint custody, or visitation rights. Now, what happens after filing? The court will issue notice to the other parent. The other parent must file a reply or written statement within the given time. The court may order mediation or counseling to resolve dispute amicably. If mediation fails, the case proceeds to trial, where both parties present their arguments and evidence. The court may appoint a child welfare officer or a psychologist to assess the child's mental and emotional well being. How can the responding parent object? Defending against a custody petition. If your spouse or partner has filed for custody and you want to oppose the claim, here are valid objections you can raise in court. Best interests of the child. Argue that the petitioning parent is not fit for custody due to work commitments, lack of emotional availability, or an unsuitable home environment. Child's established routine. Courts avoid disturbing a child's education, social life, and stability. If the child is well settled with you, argue that moving custody will disrupt the child's life. Proof of neglect or abuse. If the petitioning parent has a history of abuse, negligence, alcoholism, or unstable behavior, present police records, medical reports, or testimonies. Child's wishes. If the child has a reasonably developed and mature understanding, or the child is above 9 years of age, then the court will take the child's wishes into consideration, and if the child expresses a clear preference to stay with you, the court will consider this opinion. International custody concerns. If the other parent plans to relocate the child abroad, argue the risk of alienation, legal complication, and loss of contact with the child. Financial instability. If the petitioning parent has no stable income or support system, argue that they cannot provide for the child's education and upbringing. What if one parent lives abroad? Many parents working abroad fear losing custody if the child is in India. Here's what you need to know. Relocating a child to another country. If a parent unilaterally takes a child abroad without consent, it can be considered child abduction under the Hague Convention on International Child Abduction. Though India is not a signatory, but courts take it into account. Can an Indian court give custody to an NRI parent? Yes, if the parent proves that the child's welfare will be better abroad. If the parent has a strong bond with the child and the court is convinced that relocating will enhance the child's quality of life, custody may be granted. Important case law on NRIs. Ruchi Maju and Sanjeev Maju. Facts. The mother and father both were living in the US before the mother returned to India with her child. Legal battles ensued regarding custody of the child. The case was finally decided by the Supreme Court, which also considered jurisdictional issues as both parties had obtained conflicting orders from Indian and US courts. Outcome. The Supreme Court, while granting custody to the mother and visitation rights to the father, held that the child's welfare is paramount and that Indian courts can assume jurisdiction if it serves the child's best interests, even if the child resides overseas. Now, what is to be learned from this case? If a parent wrongfully removes the child from India or refuses custody, the Indian courts can intervene even when one or both parents are NRIs. Now, final thoughts about this issue. Your child's future is in your hands. Child custody battles are not about winning or losing. They are about securing the best future for your child. Courts prioritize child's welfare, not just parental claims. Whether you are a mother or a father, your best strategy is to focus on providing the most stable, loving, and supporting environment for your child. Do you need legal assistance in a custody battle? With over a decade of experience, I can help you navigate child custody cases, international disputes, and family law matters with a winning legal strategy. Contact me via WhatsApp or email. Details are in the description below. Subscribe to the channel and turn on notification for our next video. Thank you.